Well, in a big verdict in the Delhi riot case that we were just talking about, Delhi High Court has granted bail to these activists, Pinjra Tod activists called Natasha Narwal, Devangana Kalita and the Jamia student from Delhi, Asif Iqbal Tanha, nearly a year after they were charged under the stringent provisions of the UAPA. High Court in its verdict has also cornered the government for its attempt to stifle democracy. Here's more.
In its anxiety to suppress dissent in the mind of the state, the line between the constitutionally guaranteed right to protest and terrorist activity seems to be getting somewhat blurred. The scathing words from the Delhi High Court as it granted bail to activist Natasha Narwal in a 2020 Delhi riots case. The court then followed with this ominous declaration. If this mindset gains traction, it would be a sad day for democracy. After over a year in jail, the Delhi High Court on Tuesday granted bail to Pinjra Tod activist Natasha Narwal, Devangana Kalita and Jamia student Asif Iqbal Tanha. They were arrested in May last year under the stringent UAPA law, charged with premeditated conspiracy in the Delhi riots.
You can't keep charging everybody under terror laws, which has very, very drastic consequences. So even the court's accountability increases in such cases.
In May, Natasha Narwal was granted brief bail to cremate her father, Mahavir Narwal, who had passed away from COVID-19 during the second wave. She had surrendered soon after. The arrest of the three has become a rallying point of civil society anger against the jail instead of bail impulse. Putting that precise impulse under its hammer, the Delhi High Court observed, "It is well settled that detention in custody pending completion of trial can cause great hardship to an accused, that it is improper for any court to refuse bail as a mark of disapproval of the past conduct or to refuse bail to a person yet to be convicted only to give him a taste of imprisonment as a lesson." The judgment is a strong one and emphasizes the principle of bail not jail, seen to have been flouted repeatedly in recent times.
If a citizen's liberty is at stake and the judiciary does not stand up, which it has not stood up substantially in last few years, then I think this judgment must be welcomed by one and all, and these judges must be given tremendous applause for what they have done.
Even more scathingly, in the Asif Iqbal Tanha judgment, the Delhi High Court observes, upon a closer scrutiny of the submissions made on behalf of the state, we find that the submissions are based upon inferences drawn by the prosecuting agency and not upon factual allegations.
Justice Mridul and Justice Bambani have actually said exactly what the law is, which we sometimes lose sight of.
Protest is not terrorism, and even a call for a chakka jam is not equivalent to terrorist activity. That is the gist of the judgment of the Delhi High Court granting bail to the three activists today. The court has also cautioned courts that just because the government has sanctioned prosecution under strict UAPA provisions does not mean that the courts must accept that blindly.
Finally, in a declaration of support for the arrested activists as well as student protesters in general, the High Court observed, "Having given our anxious consideration to this aspect of likelihood of threat and terror, we are of the view that the foundations of our nation stand on surer footing than to be likely to be shaken by a protest, however vicious, organized by a tribe of college students. Natasha Narwal has become the face of the state's crackdown on its perceived enemies. The implications of today's observations by the Delhi High Court could have far-reaching consequences." With Anisha Mathur and Nalini Sharma, Bureau Report, India Today.